is an application in the matter of Dream, Eronat and CNPC International and another.
My lords.
Yes, Mr Davenport.
My lords, I appear with Mr Charles Sorensen on behalf of Mr Eronat,
Yes.
who's the claimant appellant in this particular appeal. My learned friends Richard Morgan, King's Counsel, together with Mr Edward Murley, appears on behalf of CNPC in Cliveden, the two respondents to this appeal. We very much received the note or the question through the offices of the clerk to Lord Justice Mail, so we're very grateful for that, and I'll deal with that in due course. As your lordships will apprehend, this is the appeal primarily against construction that was reached during a summary judgment.
That's the issue we'd like to hear from you both first.
Very good. Well, I'm very happy to do that. So, my lord, that's the as it were, the meat in the sandwich.
Yes.
There are, I think, two jurisdictional questions
Yes.
that we've got to deal with during the course of submissions. The first was that posed by Lord Justice Males, and the second is the, as it were, threshold jurisdiction. So I'm very happy to deal with it in all those, as it were, take it out and deal with construction first. Your lordship also knows that there is an extension of time point that doesn't suffer from a threshold principle. That is something that the Court of Appeal can consider in any event. So that, as it were, bifurcates to the principle of whether or not it was left available jurisdictionally to the judge to contemplate granting, and if so, should he have granted it or should he have not, which it is inevitably a challenge on his discretion at that point in time. So, my lord, with no more ado then I will deal with the construction argument. And your lordship will find quite a lot of this set out in our two skeleton arguments, and we tackle it head on, really from paragraph 2 onwards in our first skeleton argument. And then there's a short second skeleton argument, page 129 of the core bundle, and we deal with that on this as the second matter, dealing with the threshold issue first, and that is only briefly dealt with during the course of that skeleton argument.
Yeah.
In paragraphs 6 onwards. So my lord, what we contend for is that, or the principal basis for the judgment that we criticise is that on a proper construction of, we've called it paragraph 14A, it's 14.3A, of the 2003 indemnity, the 30-day period to appeal against the partial award ran from the date stated on the award, the 11th of April 2024, and not from the date that the award was distributed to the parties, which was the 16th of April. The arbitration claim form was filed on the 16th of May and was therefore adjudicated to be time barred and thus had no real prospect of success on the summary judgment test. And he also ruled that by paragraph 14.3b of the same document, the parties had excluded the power of the court to grant an extension of time pursuant to sections 79 and 80 subsection 5 of the Act. And just pausing for a moment and just scrolling back, so what the judge came to the conclusion was, on the proper construction of the contract, that the parties had agreed to do two things at the same time. The first was effectively to grant 2 extra days, so not 28 days as per the Act, but 30 days. And secondly, to completely shut out any possibility of an extension of time. And that's not uninteresting when looking at all of these construction questions. That's not uninteresting when looking at the learned judge's advertised experience from all his shipping case days, which your lordship might have picked up from the notes, and I can show you, I will show you if you will permit me.
But on the extension of time, the judge also said that there hadn't been an application or an explanation.
He did, and I have to deal with that. I readily accept that. I think I have some short answers, won't take your lordship's much time, but I hope that they're good enough. And I hope that they were good enough in front of the learned judge. Your lordship may have apprehended that there was a radical change of representation in this case. very nice elderly gentleman called Mr. Ian Ross, a solicitor, practicing solicitor, had represented Mr. Eronat through the entirety of the hearing. What happened was there were some questions that were posed by the arbitrators after the oral hearing had concluded. And it was during that period of time that Mr. Sorensen and I were instructed for part of the time to come on board. And what we did was then pose some questions in writing, answer some questions in writing, which had been asked by the co-arbitrators. And so we arrived at that point in time. So, my lord, I'll follow the format of the skeleton, but depart from time to time, if you wouldn't mind. So, if you want to just to follow where I'm going, I'll kind of start off at paragraph 6 of it. So, what we maintain is that the indemnity time should quite naturally run for the purpose of the contractual limitation period from the date that the award was distributed to the parties, and that the learned judge was wrong to conclude that this argument did not have a real prospect of success. So what was in front of the judge was a summary judgment test. And there's no mistaking about that. It was a summary judgment application. There was nothing wrong about bringing a summary judgment application, but as we will put before your lordships for today's purposes, there are consequences to that procedurally, including opening the door to the appeal that arise as a result, we say, of taking the CPR Part 24 route on summary judgment.
I just don't understand why everybody says that this was a summary judgment application. Summary judgment is where you decide that a claim will succeed or will fail, and you don't need to have a trial. But there had been a trial. All the facts were found in the award. There was no scope for any further evidence to come in ever on an appeal under Section 69. So the question was the decision right or wrong? That's what Section 69 is for. And really, this was a prior question about whether the jurisdiction of the court had been excluded if you didn't get your application in within 30 days.
Well, my lord, I think what happened, as you can see, is it all conflated. But we had to deal with the application that was before us. So,
I appreciate that. It may not make much difference because ultimately it's a question of what does clause 14 mean.
Yeah, I respectfully agree with your lordship. It's exactly what it should do. I mean, my submissions, if I was under a sort of chess clock game where one played sort of accelerated chess, and you said we've got 10 minutes, I could do it. Because what really our most important point is that the learned judge really didn't look as he should have done, first and foremost, at the clause. And when you look at the rhythm, as it were, of the judgment, the order of the judgment, and when you look at the transcript, we put that on the essential reading list. You might not have thanked us for doing that, and I apologise for doing that. I think it probably should have been on the sort of preferred reading list rather than the essential reading list. But there is at least one passage I'd just like to show to you. And so my submission, for good or for bad, is that the learned judge really had a short amount of time. He said so right at the beginning. He told us to cut our cloth accordingly, which we did. And he basically went hard at it from the Act's perspective, and he equiparated the position with the Act. So he really, as it were, used the Act and other references that he really should have left well alone to come to the point whereby he said, well, there we are, it's very clear what clause 14.3 meant. And that was completely the wrong way round. Clause 14.3, en passant, tries, nobody's had to test this yet, tries to open not only a contractual right of appeal on the law, but also on the facts. So one of the submissions that we make in writing an orally is that if you step back and you look at the intent of the parties from what's in front of you, it was quite clear that the parties were doing their very best to open a wide and permissive regime for appeals, not to end up with this extraordinary trap, particularly if one looked at the experiences of the learned judge, which is that it could be played, as it were, to time to run the time clock down, would have meant that there was no real way to have got around the problems posed by the combination of getting rid of your extensions of time and at the same time only giving yourself 2 extra days for the price of doing so, which seems hardly likely to have happened. So I don't want to get off track, but the big point is look at the clause in the context of it. The clause is wide and permissive, and it was presented as common ground before the learned judge that the construction urged by the defendant meant that a party could lose their contractual right of appeal despite not receiving a copy of the award or even being informed of the results. And Mr Justice Bryan's response to that was to say, in the vernacular, well, so what? Because that's what the Act provides for. But there was one big and important omission about that, because the Act doesn't only provide for that, because the Act also provides for extensions of time. And you've got to be able to satisfy the court. But when one looks at those well-known factors in a couple of the authorities we've put in before your lordships, those factors include which parties were contributing to the delay, the ability of the court essentially to have a look through the reality of what happened. And so that's a very important missing pillar of the whole proposition, because with the extension of time is the balancing factor against the obligation.
You say the clause is wide and permissive, and certainly it tries to be, but does it matter that it is largely ineffective, so that you can't contract out of section 67 and 68? I would have thought, unless you're going to submit otherwise, you can't confer jurisdiction on the court to have an appeal on a question of fact.
Well,
my lord, there's trying to do things but not succeeding. Does that affect construction?
My lord, we put before the learned judge that it wasn't a masterpiece, this agreement. You know, we put before him that it was full of holes and inconsistencies, but that the overall intention of the parties, when you're going to boil down to have a look at clause 14.3, was that it was intending, even if it didn't get there, to be wide and permissive. And that's quite important, because if you're going to come to the conclusion, one side of the fence or the other, that actually it's restrictive, because that's a shorthand for what the learned judge must have found. He must have found that it's very restrictive. And the trade-off is 2 days extra for walking away from your entire rights under the extension of time principles. And the extension of time principles, given the murky nature of the games that can be played in arbitrations that the learned judge colourfully pointed us to, is rather important.
So, your point about the extension of time being the balance, as I think you
within
called
the
it,
Act itself, my lord, yeah.
that assumes that the judge was right in his interpretation of the word rendered in clause 14.3.
Well, I'm not really giving it away. I thought about this. I accept, my lord, that there has to be consistency throughout. So I understand why your lordship puts that to me. I mean, my proposition is a simple one, which is that clause 14.3 stands to be interpreted on its own and properly construed, doesn't bear the construction that the learned judge came up with.
But wait a minute, why should 14.3 be construed on its own as opposed to in the context of the agreement, including 14.2, which is of some importance?
Yes, yeah, I'll come back to 14.2. Well, my lord, of course you're right, that everything is potentially considered for within the document. And my answer to 14.2, when I come to it, is there's no term of art to the word rendered. And so where there's a term of art, it's much easier, better, and probably more correct to be able to make the start from the point that it probably means the same thing. But where you have a general word that doesn't have a sort of term of art meaning, then you're not, as it were, hidebound by that. But I'm not going to commit the sin of just trying to have my cake and eat it. But I am saying that I think I'm saying on either way that one approaches this question, we have a legitimate concern about the way that the judge ended up. when looking at the entirety of the material properly to be put before him, one gets back to 14.3 ultimately to see, well, what does it actually mean? What does the word rendered in this case mean? And it was really a question of choices. It was really a question of, does it mean nothing more than the art of creation? Does it reflect the word made? Or does it reflect the word delivered? And on the straight choice, our submission was, well, it obviously reflects the word delivered, we're right. But there's an important second point, which is we didn't have to be right on the day. We just had to have something that was arguably right. Well, because we were facing a summary judgment.
Well, I follow, but if it's a short question of interpretation of a contract, then the judge is perfectly entitled to decide it one way or the other on an application for summary judgment.
I do accept that. But normally, in one's experience, how that is set up is a slightly different approach. I fully accept and acknowledge that my learned friends, I think at paragraph 7 of their skeleton argument, before the hearing for the learned judge, did say it's a short point of construction. So I get it. But I think it didn't emerge until that time where that skeleton came. It wasn't really presented as this is a short point of construction. It was set down for an hour's hearing. There was an extra 30 minutes won by being an enforcement application, which was tacked onto the end of it. And so the learned judge started off with a maximum of an hour and 30 minutes to deal with it. And without a question of doubt, it was presented as a Part 24 summary judgment application. He dealt with it as a Part 24 summary judgment application. He dismissed the application for permission to appeal, as it were, as a reverse of, well, if I haven't found for you on the construction, I can hardly find that there's a chance of an appeal. Although I should show you that he slightly merges, I think it's paragraphs 76 and 79 of his judgment at the end, that he deals with 76 is the summary judgment paragraph disposed with all the language of summary judgment, and in paragraph 79 he then puts in section 69 judgment, because of course they're two completely different tests. One is an arguable case test, and section 69.8 is going to be whether or not there's a point of some general importance or principle that needs to emerge, because they're completely different tests for that purpose. My lords, I'm trying to get back on track, and it might just help if I just show your lordships the transcript very briefly. This is in what we call supplemental bundle. Is it? No, it's in the core bundle.
Core bundle tab 5.
Thank you very much, Mike. And if I could just show you a couple of extracts just to, as it were, set it up the rest of the arguments. So if one was to find page 49, I'm looking at the bottom right-hand corner.
Yeah.
Thank you. And then, so at D, that's the first thing essentially that Mr Justice Bryan says, apart from hello to Mr Morgan. And he starts off that D to E is, we've only got a short amount of time, both need you to cut your cloth accordingly. Then E and F, he says, I've read the skeletons, thanks. The applicable principles are all straightforward. It just seemed to me, so he gets on the right start, that the real sort of focus is going to have to be on the contractual clause. And he's right about that, but he really departs from it. And then he says, at the end of the day, subject to one thing, which is that neither of you, I think, really go into any great detail about the Arbitration Act. And it did seem to me, although you have both got it in the authorities bundle, it did seem to me that actually before you get to the contractual construction, it's important to bear in mind the regime under the Act, which draws a very sharp distinction between the making of an award and time running from the making of the award and notification to the parties, which is something that comes subsequently. Again, anyone, any shipping solicitor or any barrister who practiced for the best of 30 years in shipping knows that in fact you do not get 28 days under the Arbitration Act, because if someone thinks they've won, they do not pay the arbitrator until the day, the 28th day, or sometimes even after the 28 days, and the claim is time barred before either party knows what the award says. And he goes on to say, so I think when I'll receive submissions that, well, common sense indicates X, so you're foreseeing where I'm going from, I think it's perhaps worth bearing in mind that the regime under the Arbitration Act is because that is part of the backdrop, it seems to me. While I'm on the transcript, so I think have to go back to it, could you go forward to page 60? Mr Morgan is coming to the end of his submissions, right at the end of his submissions, and he hears in the middle of the page, as it were, he summarises his case, meaning you can see between C and D, he says, I think you sent at least one case which says that limitation points are amenable to summary judgment or reverse summary judgment. And then between F and G, he says, as it were, the closing remarks to Mr Morgan. So I think you'll say, and I think it will probably be common ground, that it is amenable to reverse summary judgment. Mr Davenport will be submitting that, I suppose. He has got a real prospect of success, but that's where he's aiming at, is the summary judgment threshold, and therefore, or some other reason for trial, which is still a Part 24 answer. Then to show you, so we don't have to come back. Yeah, can I just show you, this is going forward, but it just means we don't have to come back here, which might help. If we go right the way forward to page 81, bottom right hand, this is now after he's given judgment on the summary judgment application, and I have made an application for permission to appeal. And at C and D, and this is the entirety of my learned friend's submissions on leave to appeal. So Mr Justice Bryan said, all right, anything you want to say in response, Mr Morgan? Mr Morgan says, well, it is obviously an application for permission under CPR 52.6, which he was right about. My learned friend is not saying there is some other compelling reason for an appeal, nor could he. In terms of whether the court considers the appeal to have a real prospect of success, your lordship described my learned friend's submissions as hopeless. And I think it was our position about the contention we made in respect of the proper interpretation of the clause. We adopt that characterisation. If he really thinks he has got a real prospect, then he should ask the Court of Appeal. Right, that's it. And of course, we find ourselves in that position now. So, what we really are saying to you is that rather than really actually applying the well-established principles of contractual construction, which there was a nod to, and in the judgment it's dealt with extremely cursorily, as opposed to the setting out of the position of the Act. And actually, it might help just in very quickly, if I walk you very quickly through the judgment. I know you will have read it carefully, but if I can just show you as we go through, then you can see what parts come up where.
Just before we go there, it looks as if it was the judge's own point that the Court of Appeal wouldn't have jurisdiction to give permission to appeal. Is that right? Doesn't seem to have.
Yeah, it doesn't seem to have been taken.
Seems to have been accepted by Mr Morgan at page 81D.
Yeah.
That you could go and ask the Court.
Absolutely. Yeah. Absolutely.
Yeah. Okay.
Yeah. Well, it was most definitely the judge's own point. And when I get to this part of the judgment, I'll show you, I hope fairly, where he expresses it. So what he did, although it was an extempore, to be fair, I think from memory, and I can't show you in terms of timing points, but I think that the learned judge said, right, cameras off, video off, I'll collect my thoughts, and then he gave a summary, gave an extempore judgment, and this is the relatively longer extempore judgment that you had before you on the same afternoon. And so he deals with the facts, and I can say that...
So just sorry, Mr Davenport, to interrupt you. In our copy of the judgment,
yes,
we've got under section G, permission to appeal, in which at paragraph 79,
yeah,
the judge does say that in accordance with section 69(8) of the Act, there is no right. So when the document that we've got in our bundle is what, a corrected transcript?
I think it is. Oh, yes, I believe it is a corrected transcript.
Well, I think it is a corrected transcript, but I think that's what he said at the time in giving judgment.
Right. So this is a tidied up version, if you like, of the extempore judgment.
I believe so, my lord.
But my recollection is the learned judge identified that as being the proper basis. I'll address you on
yes.
Right. Because that doesn't emerge clearly from the transcript of the hearing.
Oh, no.
when the
No.
section 69 point seems to be a bit of an afterthought.
Yeah,
But by the
exactly.
time he gets to his final version,
It's firmed up.
it's there.
During the hearing, it was much more. I could be wrong about this. You know, that's how it was contemplated, and there was an interchange, and I think we quoted one of our skeletons, which was, "Well, we'll give you a chance, Mr. Davenport, to come back and address further." And I said I would, and of course that moment was never available.
Right.
I don't really lay complaint about that because that's the nature of how it was in the afternoon. And thank you very much indeed for pointing out para 79 and indeed 78. I was going to show you on that, and when I did my best from memory, I said it was paragraph 76 and 79. I said it was actually 76, 78 and 9. 76, if you just quickly look above, that's very much a part 24 test.
Yeah.
So that's really, and the day, really, if one looks at it like the British Lions rugby victory recently, was mostly about part 24 summary judgment. And it really, the section 69 point really only came in that last minute. So it's really the nature of it during the day. So I was doing my best to do a sort of tour d'horizon of this judgment. And we can see above para 4 the applicable legal principles, which are mostly in respect of summary judgment. Of course, the reference to the Easy Air case, and at paragraph 5. And then at paragraph 6, it's possible to make a summary judgment application based on a defence of limitation to a claim. Nobody was contending differently. But I don't know if you picked up on this story. At 13:19, the hearing was at 1400 hours. At 13:19, an email was sent by the judge containing 3 authorities. That was sent to our solicitors, not to counsel directly. We got it sometime shortly afterwards. And those 3 authorities were an authority, none of them I think really on point, and this is the only one I think that gets referred to by the learned judge. But one of them was the judge, his own judgment. One of them, as it turns out, was the judge as an advocate when he was a senior junior. And this third one was the idea that you could have summary judgment based on a defence of limitation to a claim. So without question, the summary judgment aspect was at the forefront of his mind because he actually sent it to us. And then the facts, and we're perfectly content that those are an accurate record of the facts. And so we don't lay any criticism on that. You can use that as a basis for contemplation. And then the making of the award in the Arbitration Act is up from paragraphs 19 till about 41. And that really dominates the matter. And he comes to a steady conclusion, which is that when you look at sections 54 and 55 of the Arbitration Act, that there is a very clear distinction drawn between the date of creation of the award and the date of notification of the award. And really, and as we hanged for a sheep as for a lamb, what this judgment in his approach to it did thereafter was to reinforce in his mind that the parties were falling in line in respect of the same approach to how he saw the Act apply. And of course, I don't disagree with anything that he said about the Act. It was just that it didn't really apply to clause 14.3a. So he sets that out, and then at 42, the arbitration agreement and its construction comes onto it, and 43, he looks at the word render. At 14.2, which is render its decision in English. I'll have some short remarks about that in due course. And then he does some highlights on page 38 of 14.3, and he looks at 14.3 and says it must have the same meaning as in clause 14.2b. I take exception to that. A word like that doesn't have to have the same meaning as in clause 14.2b. It might, but in this instance, we respectfully submit that it shouldn't. Then he starts talking about the ICC rules of arbitration, and the spoiler alert is that he started off by asking why on earth it was that my friends put the ICC rules of arbitration in, and at the end ends up using a bit of it. And then there's LCIA guidance. Now, during submissions that I made to him, he said, well, don't worry, Mr. Dampton, I'm not going to place much emphasis on LCIA guidance. Then he does place emphasis on LCIA guidance. And LCIA guidance isn't even in the bundle before your lordships, because my learned friends don't rely upon it anymore, or seemingly don't. And he really sort of reinforces his conclusions that our contention is, as he says, hopeless. That word hopeless in the first sentence of paragraph 53 and 55, his own highlighting time runs from the date of award, not notification provisions, and likens it to how it is under the Act. And then he goes on to a different date. There was some evidence before him. When I come to the extension of time point, which I'll deal with briefly, my submissions in short will be there was enough before him to deal with the point that he had to deal with. And there was really nothing to the contrary. So the facts were pretty clear. Then extension of time starts at paragraph 62. The principles are really 62 and 63. And then 64 onwards are what you would think is the dealing with the application for the extension of time and his discretion. But he doesn't use or compare any of the factors at all. And he really stops at the point of saying, well, there's nothing before me. He refers in 67 to the Commercial Court Guide for that purpose. And then at 70, he wraps it all up and says, had I had jurisdiction to extend time, I'm satisfied there's an archetypal case where the court would not extend time in the absence of any proper application to extend. So I accept that I've got to deal with that, and I will try and deal with that. And then there was a conclusion, and then he deals with the permission to appeal. So this is, as it were, all wrapped up, because I'd heard the judgment, then I made the application to appeal. And so, as your lordship, Lord Justice Lewison rightly says, it is an improved version, and a, as it were, to join together. And then he deals with it in the way that I think I've shown. And 74, he narrates the real prospects of success in arguing. So he narrates, first of all, the summary judgment part. Then he refers to the Section 69 appeal. And my position on that is that the underlying document, the appeal, which was sent in May, that is a section, that is a contractual right appeal, and then comes through the guidance of the gateway of 69, is it 2A, which is the parties can agree provision. So it relates to 69 in that way, but it is essentially a contractual right, but nonetheless, that's the 69 element, and that's the only part of the 69. And thereafter, what happens is that he deals with it compendiously, one would say. 76 is definitely CPR Part 24 test, any prospects of success, still less any real prospect of success. And then thereafter, he talks about the far-reaching limitations on the right to appeal under Section 69. And on 78 and 79, he, as it were, conflates both of these. He says, I don't consider the question sought to be appealed whether the 69 appeal stands no real prospect of success, as it is contractually time barred. So that's really the summary judgment test in respect of the document that is called, he calls it the Section 69 appeal, is one of general importance. So that's the 69 test, or one for which some other special reason should be considered by the Court of Appeal. On the contrary, the question not only stands no real prospect of success, that's again the Part 24 test, but is...
I don't understand, I'm not really sure why you keep referring to the Part 24 test. He's talking now about the test for granting permission to appeal, isn't he?
He is, my lord, but I'm just drawing this distinction, if it's appropriate to do so, between looking at the summary judgment test that he's just applied, and I was submitting to him that there was a chance that the Court of Appeal could view otherwise, and that therefore he should acknowledge that and had to look at the summary judgment test. And so the appeal would be, as it is, that he misapplied the summary judgment test, and that if it was correctly applied, the Court of Appeal would, as I invited to, come to the conclusion that the construction for which we contended had to have stood some chance of being seriously arguable, and that therefore it would overcome the relevant test. So I think he's dealing with those submissions. So, my lord, I apologise if it's boring the
In
court.
76, he says quite satisfied that any appeals will not have any prospect of success. So that's the straightforward permission to appeal.
Correct, my lord. Yeah.
And then in 78, he says, I do not consider the question sought to be appealed as one of general importance or one which for some other special reason should be considered by the Court of Appeal.
Which I think is the Section 69 test. I mean, there is obviously, it's a fallback provision of some other purpose.
Question about whether or not he should grant permission to, isn't it? Although you require the judge's permission under Section 69(8), it's still the same permission to appeal test.
No, I think it's not, my lord, with respect.
There's a restriction. I think it does say that the judge shouldn't give permission unless it's one
Yes.
point of general importance.
But that's what he's considering, isn't
Yeah.
it?
Yeah. Well, thank you, my lords. Just Section 69(8), there's two sentences to it. The first sentence is the decision of the Court of an Appeal, and it says on an appeal, under this section shall be treated as a judgment of the court for the purposes of a further appeal. And that's referring to, as it were, the High Court judge being the determinant of the permission to appeal. The second sentence is, but no such appeal lies without leave of the court shall not be given unless the court considers that the question is one of general importance. So I think that or is one which for some other special reason should be considered by the Court of Appeal.
That's what the judge is considering in his paragraph 78.
That's the point I'm trying to make, is that all he's doing here is considering leave to appeal. It's nothing to do with Part 24.
Well, my lord, I mean, I don't want to repeat myself. The only point I'm inviting you to look at is that in this section, which could be taken to be 76 through to 79, that he's dealing with both, and the language gets intermixed. And
Doesn't it work like this though? If his decision on the construction of the clause 14 is a decision under Section 69, then the position is that the judge has refused permission to appeal, and we have no power to grant that permission. But if his decision is not a decision under Section 69, then Section 69(8) does not apply, and we have the ordinary real prospect of success test.
I think your lordship is right. I mean, I have arguments as to the threshold test, and they essentially come down to twofold. The first is that this is a CPR appeal, and if you as a party, say the respondents, seek to bring proceedings under the civil procedural rules, and you use the machinery that is not provided for under the Arbitration Act, then you take your chances, but you live or die by the CPR, and you bring to the party the continued right to stay within the CPR. And so our primary submission is therefore you make yourself open to an appeal, a straightforward Part 52 appeal from a Part 24 summary judgment. You've got a High Court judge, gives a ruling, and that should be considered. The second position is the more exquisite analysis of those authorities, which are, most of them are on 67 and 68, but the Section 69 authorities are on whether or not there is a fair distinction to be drawn between substantive appeal points and interlocutory, preliminary, or case management elements, which are, as it were, non-substantive. My learned friend's position about this, it says, so what? It's all part of the process that gets you to the termination, that's the end of it. To which we say, well, that's not what the authorities are really consistently saying. And there's an interesting authority where I think, first of all, Lord Justice Bryan sat in the oil, or the Iranian oil case. But there's also the Manchester City case, which had Lord Panic, I think, applying for Manchester City in that particular case. And I think it's Sir Julian Flo who comes to the conclusion that it's a thorny problem, and that it's very difficult to be able to discern between, as well, the substantive part of proceedings and whether or not other elements are not to be determined. So I could and sure should, whether through the written submissions or the oral
Well,
submissions.
can we stick for the moment with the interpretation of clause
Yeah.
14.3?
Absolutely.
Now, I just want to understand something procedurally, which I'm not quite clear about.
Yeah.
The judge at paragraph 5 refers to the principles he's going to apply on summary judgment. And one of those principles is that if there's a short point of construction, the judge can decide it.
Yeah.
And he decides it, as I understand it, at paragraph 46 of his judgment. He says he's satisfied that 30 days runs from the date when the award was made. So he's decided that as a question of construction. You have made the point many times that it's all to do with whether your construction is arguable.
Yeah.
Well, if that is the test, and let's suppose that your construction is arguable,
Yeah.
who then decides whether the argument is right?
Can I take the point against myself and try to meet your lordship? As I said, I think if it's set up as a summary judgment application, and let's face it, it doesn't have to be dealt with purely as a point of construction, but if it's, as it were, fairly set up, as this is going to be a point of construction, this is what we're all dealing with, it's a once and for all, then of course that judge is the one who makes the determination. I accept that that is the case.
But it hardly seems consistent with the overriding objective to have one hearing to decide whether a point of construction is arguable, and another one to decide whether it's right.
Well, I mean, the commercial court is very often reluctant, and the Chancery Division reluctant, to wade into preliminary points, because the point it makes over and over again is so many times that it seems that you can just take a neat point. It's not just a neat point, because it's bound up in the facts, or there are some procedural facts that need to be argued out. There's the reasons why what appears to be straightforward isn't always straightforward. And
Well,
so,
that would be a reason for not deciding it. I agree.
Yeah.
And that's what Easy Air says.
Yeah,
If there's more to come out, then you don't decide it. But if you're satisfied you've got all the materials necessary, you can decide it.
Yes, I mean, I think that what happened was it was a little bit like a sort of a snowball or something that gathers moss. It wasn't really set up as anything other than a summary judgment application. There was a witness statement that came with it, and the whole purport of the witness statement wasn't to say, look, the Arbitration Act is straightforward. This is in line with the Arbitration Act. They've referred to LCIA. They must have referred to the same thing. And by the way, look at a couple of other words and a few other things. That's it. Not at all. That's why I showed you the passage that showed that the judge was not very impressed with either of us, that we weren't putting the Arbitration Act in front of him, and that he was doing it for us, and that he was really leading the charge in this respect. What actually really both parties were trying to say was some pure construction arguments. My learned friend had dipped into various other places to try and find the word rendered, and so worked, as it were, teleologically backwards from the point of rendered to try and get to a point of construction, which was close to what was not a term of art in the first place. And what we were trying to do is to say, well, don't do any of that. You don't need to overcomplicate it. You just have to look and see what the parties were doing in this far from perfect contract. And what they were trying to do was to make a provision for a straightforward 30 days from the time that you actually know whether or not you've won or lost. So that was how it really was. So I think my answer to your lordship is, whilst I agree in principle that the determining judge, there's got to be a buck-stopping moment where the judge can say, now, this is appropriate to deal with it, I am going to deal with it, I do deal with it, and that's it. So that it is determined in that way. Normally, that's a consensual process, because normally what happens is the party that's on the receiving end, as a first strike, says, well, hold on a minute, this isn't appropriate to deal with in that way. And really what happened, although I accept that my learned friend did a day or so before put it in the skeleton argument, this is a short point of construction, whatever that period of time is, it is. But that really isn't how it was. How, as you can see for yourself, it was dealt with by a summary judgment application. The judge comes in and says, we haven't got much time, you need to crack on. We do crack on because they want to get to their notice of enforcement point, which is another 30 minutes worth, at least allowed for in time budgeting. And there had been a direction, I think by Mr Justice Henshaw, that the summary judgment, quote unquote, application was going to be heard first, and it bumped the date that we were going to have for the full appeal. We had a date for the full appeal, but it was literally bumped by the summary judgment application. So that is how it really was, rather than we're just going to be able to cut down time, which is the justification for having a preliminary point, and so it really didn't have those characteristics.
Right.
Thank you. We know that the principles of construction are settled law, and of course there is always a temptation to say, well, they're settled law, we all know what it is, and then you don't really do it, or you don't apply it. Now, 99% of the time, of course, advocates and judges do, they try to. But with no disrespect to the learned judge, that wasn't the categorisation of the day. It was a lot of time was spent on the Act, as I've said, not a lot of time, well, no time whatsoever, was taken up in the judgment by actually looking at what had to be looked at. And really what had to be looked at boils down, as we say, to a fair interpretation of the clause itself. And there's a couple of the authorities we've put in our skeleton argument just for the reference of paragraph 15 and 20. 15 is the Lord Hoffman in Chartbrook. What one's looking for is what a reasonable person having all the background knowledge which would have been available to the parties would have understood them to be using the language in the context contract to mean. So what would these people have done? Not what would two shipping lawyers have assumed it to mean. And by the way, neither Mr. Morgan nor I claim to have been shipping lawyers and made that clear to the judge at the time.
It's not really a feature which is unique to shipping law.
No,
It applies to arbitration generally. It
Yes.
applies to any arbitration where, in any field, where the arbitrator's fees are not secured.
Yep.
You won't get the award out of them
Yes, you may.
until you pay them, of course.
No, and of course that's right.
And everybody who's dealing in arbitration
Arbitrations.
of any kind ought to know that.
Yes, exactly. But as I've said, our representation was rather different. Coming in, as it were, late in the day. Mr. Morgan was there throughout. But I can tell. That's right.
I object to that. My learned friend, first of all, was instructed in May of 2023 and appeared on the record. I was not instructed, and he should know that.
I apologise. I certainly didn't mean to offend my learned friend. I take it back if he feels offensive. So, my lord.
Does my learned friend accept that he was instructed on in May 2023?
Well, I don't think this is really going to help us, Mr. Morgan.
My lord, certainly I didn't mean any offence to my learned friend whatsoever. All I meant to say was really to my lord's intervention was that yes, that's of course understood, and I sound like a broken record, but the only point that I wanted your lordship to accept is that that's right if you accepted that the trade-off of the 2 days was walking out of the extension of time because of the waiver in section 14.3b of the Act. Just on the instruction of us, we were on and off instructed
Well, I
from
don't
a
think it
date
matters
in
who
time.
was instructed when.
Of course.
As my lord says, it is commonplace in any kind of arbitration
Yeah.
that you don't actually receive the award until sometime after it is made because the arbitrators want to be
Yeah,
paid.
and I'm fully agreeing with
You
this.
would probably accept, would you, that in interpreting any contract, legal background can be of relevance?
Can be of relevance, but, and there's an interesting, one of the authorities we put before your lordships, when talking about extensions of time, I think it's Mr Justice Coleman, who had plenty of experience of dealing with these sorts of applications. He balances the two policies. One is the policy that there has to be a sort of, the reputation of the English commercial court was for light touch interference and getting on with things and not encouraging, as it were, delay to the arbitral process. But he counters that by saying that you're actually sometimes dealing with non-sophisticated parties. You're not always just dealing with, as it were, the most sophisticated of parties or armed to the teeth with lawyers. And so that is the balance to be drawn. So whilst I accept everything that your lordship said, and I accept completely that the Arbitration Act as a code sets that out. But the important caveat or balancing provision is the fact that there is the right for the court to grant the extension of time. And in my respectful submission, that's quite important. And so the learned judge had to see for himself what he was construing. And the result that he came up with was both that the rendered meant back to the award that it was dated, and there was really no basis for that. And secondly, that they shut the door completely on the ability to seek an extension of time jurisdictionally. So if that's the case, then then he had to have really just told himself, is it really likely
Hmm.
that the parties would have done that? And did they try and do that here? And the purpose of the transcript and the judgment is really so your lordships can get the flavour of the matter, which is that this is not a perfect contract, but the overwhelming likelihood was that these parties were trying to give themselves 30 days from the date of notification, because that's normal to an unsophisticated party, and it's highly unlikely that they would have walked away from the extension of time. Now, without saying I'm having my cake and eat it, I'm answering a question that my Lord Justice Lewison put to me earlier. If, by contrast, I'm wrong about those primary submissions, then I'm surely right about the jurisdictional ability to have the extension of time, because that, we say, keeping it short, is a gateway provision. So when one looks at clause 14.3 A and B, the B, it sets itself up to be a waiver, or rather a partial waiver, because it obviously admits for the contractual provision of the 30-day appeal point under 14.3 A. So once you're in, you're in. It doesn't have to be, as it were, waiver of all things. So this is a submission you'll either accept or you won't. I don't have authorities to, I think, put in front of you to suggest to one reading of this or the other. But it's a simple submission, which is that if we're in the position whereby we have qualified under 14.3A, we are then within section 69 because the parties have granted the right to proceed, and then you have the ability to profit from the extension of time. So I think I'm saying to you, lordships, that either the learned judge really had to find one consistent finding or the other. He either had to find a consistent finding, which was that it was the clause 14.3a was the contention that we had put before him, namely that there was an opt-out from trailing behind the Arbitration Act, so you couldn't equiparate with the Arbitration Act, which was very much what the judge wanted to do. But that if we were wrong about that, then we had to be consistently wrong, and consistently wrong would have allowed us to have the extension of time.
Had you asked for it, which you hadn't?
Well, I'll come back to the how it was handled. I accept that is not anybody's finest hour. And what that boils down to is, if one looks at the test under the Act, there isn't any obligation to put evidence before the tribunal court. I'm just trying to remember which section it is. Is it section 79?
80, isn't it?
Is it 80? Thank you. I'm very good. 85. Anyway, I've scribbled all over it. And there isn't any obligation to put any evidence. Yeah, it's 79, I think, actually. To start with, I think your lordship is exactly right about extension and bridging of periods. The power is in 85, so I think they go together. And in fact, section 79, if you've got it, it's in tab 2. We've got some of the parts of the Arbitration Act quoted there. So 79.1, it's again one of these non-mandatory provisions. Unless the parties otherwise agree, the court may by order extend any time limits agreed by them in relation to any matter. And then sub 3, the court shall not exercise its power to extend a time limit unless it is satisfied that any available recourse to the tribunal has been done, and that a substantial injustice will otherwise be done. So that, as it were, is the test under section 79. And of course, what was being referred to was the Commercial Court Guide, Order 9 on time limits. I'm not sure that's in the bundle. It's non-mandatory, as we know. I mean, it's good advisory, but it's non-mandatory. It doesn't actually say evidence, unless I'm misreading it. So I've got it in front of me. It says, Order 9.1, an application to challenge an award under Section 67 or 8 or to an appeal under Section 69 of the Act must be brought within
Which paragraph are you reading from?
Order 9.1, my lord, which I think was the only one that was referred to. But
Sorry, I thought you were reading from the Commercial Court Guide.
I was, my lord.
Section O, I think you mean.
Oh, sorry, beg your pardon. Sorry. O 9.
Section O.
O. Which is in volume 2. and it says at 092, the court has power to vary the period of 28 days fixed by section 70 subsection 3 of the 96 Act. However, it's important that any challenge to an award be pursued without delay, and the court will require cogent reasons for extending time. So I fully accept that. What we are saying is that there was enough before the court to have seen to have amounted to cogent time. And when one looks at the three primary aspects of the tests, which I'll come to, as in two authorities that we've put before the court, the length of the time is the most important aspect, and at the outside it was 5 days. Whether there was a contributing factor by the respondent, there wasn't. I fully accept that. And other factors such as further down the list, whether there's any prejudice caused, there couldn't have been any prejudice caused, and a range of factors which I would take your lordships to. When I come to it, I keep getting out of step by trying to advertise, foreshadowing where I'm going.
If you're making an application for a variation of the 28 days, then that engages 62(9), doesn't it? And that requires that any application be made in the arbitration itself.
Well, my lord, this was no attempt to bring an application within the arbitration itself. This was an application before the High Court judge for an extension of time in respect of a fallback position.
But wait a minute.
Yep.
If you're right
Yep.
on the meaning of clause 14.3, you don't need an extension of time.
No, exactly.
So the question of an extension of time only arises if you're wrong about 14.3. And if you're wrong about 14.3, then your arbitration claim form was served after the expiry of the time limit. So my lord is right, is he not, in saying that this insofar as you needed an extension of time, it wasn't an application made after the time limit had expired, and therefore it had to be made under Part 62 in the claim form. And that was one of the points the judge made.
Well, and the judge noted my candour in dealing with what we hadn't done. And of course, I had no other position to adopt than to fully recognise that there hadn't been an application which had been put before the court. What the judge had, though, was material before him, which was in the form of, as it were, informal evidence. And I use that expression advisedly because that was an approach that my learned friends had taken in respect of evidence from the respondent in another way, and said, well, there is nonetheless evidence before them, not going to the extension of time point. But what we had before the court was an email exchange between the LCIA casework provision and the arbitrators, LCIA and the parties. This is to be found in the supplemental bundle. If I take myself out of my turn, and I'm afraid you have to work backwards from this little tab. So if you find tab 2. You take the last page, which is 146. So the award we know is dated the 11th of April. Here, this is an email from the LCA caseworker, and it's 7 o'clock in the evening on the 16th of April.
Yeah.
And it's sent out to a variety of solicitors, including ian@finross.com. And then there is an interchange between the parties with those on the distribution list copied in, can I just show your lordships page 141? You have to scroll forward, but then that's coming more later in date. And at the bottom of the page, on the 30th of April, Neil Shearsing wrote to Mr Ross, due to the delivery failure, messages regarding the two email addresses, and then he sets them out, these Ian at Finn Ross and his his assistant Alexandra Chesniak. I forward the arbitral tribunal's email of yesterday below to the email address indicated by you. So this is now the 30th of April in respect of events going down. You can see at the top of that page, then for the first time, Mr Ross replies very inappropriately saying, "Dear Niels, I'm coming my 75th birthday next week, and then I need to trouble you on one point, please. The tribunal's partial award was delivered somewhat later than planned, and is a very lengthy document. It deserves careful analysis. The point of which is not clear to me is if the tribunal prescribed a period for submitting an appeal, and if so, from what period. I do not think the partial award reached Friedhelm Eronat until April the 17th. Could I ask you please to help on that question?" To which, quite appropriately, the chairman of the tribunal responds, and he says at page 139, "I don't wish to appear rude, second paragraph, please don't write ex parte communications." Third paragraph, on the 16th of April, the partial award was delivered by the LCIA, so we know that that's the case there. Over the page on the 17th of April, the tribunal issued directions regarding cost submissions, and he repeats them. And then the penultimate paragraph concerning issues of appeal, it's not appropriate for the tribunal to provide any guidance to counsel, referring to Mr Ross. So, my lord, we get the timeline from that.
What is the question that Mr Ross is asking? The time for appeal is prescribed by the contract.
Yeah,
It's not up to the arbitrators.
No, of course not.
So it's completely wrong-headed.
completely. I completely agree. I don't show it to you for mercy. I merely show it to you to show the timeline of what was going down. So without
Now,
question.
you got the award.
Yeah.
The award was sent
Yeah.
electronically on the 16th of
Yeah.
April.
Exactly. That's the most important point. And so what that consequential loss of that 5 days, the 11th to the 16th, is the same as the 5 days. It would have been in time had it been delivered on the 16th, which it wasn't.
Do we know why there was a delay of 5 days? Was it
No.
Easter or something?
It's a very good question. None of us have tried to conjure with why that was the case. I think the learned judge, either in the transcript or in the judgment, said, well, these things happen, and admin reasons. And I think it was part of our submissions. I mean, what we were saying is the clause itself was a departure from the Act because the parties wanted to they used the word rendered. They didn't use a word that was a term of art. They used this non-term of art word. And so therefore what they were driving at was a fresh 30 days.
I just wondered because unlike the ICC, the LCIA doesn't have a review procedure whereby it looks to see whether it is satisfied with the award.
Yeah.
It just sends it out. And under LCIA practice, there's no question of exercising a lien for the award, for the costs, because the LCIA takes deposits in advance, so the arbitrators are always going to get paid.
But that was very much addressed, I think, in the discussions with the learned judge. He said, well, they do take healthy deposits, but it may be that they hadn't taken a healthy deposit enough. I don't think anybody was trying to come up with an idea as to why there was this delay. I mean, I just think it was accepted that there was a delay, and there could have been a bigger delay. For the construction of the clause point, of course, it might have been 5 days, but it could have been 35 days.
Well, I was just thinking in terms of legal background, which we talked about before, which is one thing is that people would know that arbitrators do exercise a lien for their fees.
Yeah.
But on the other hand, if you agree LCIA,
Yep.
you know that the arbitrators are not going
Yeah.
to exercise a lien for
Yeah.
their fees
Basically,
because
they've
they're
got
going to be
deposits.
secured.
Yeah.
And therefore you would expect that whatever rendering might mean that the gap between signing of the award and sending it out will be a very short one. Okay, anyway, there we are.
Sorry, I
I
yield.
hope I'm assisting. It wasn't Easter, my lord. It's Thursday, the 11th of April, and Tuesday, the 16th of April. So there's a weekend in between. So sent out.
Weekend, but no bank holidays or anything. Okay, thank you.
Thank you, my lord. I accept that there's not a lot that was before the court, but nonetheless, there wasn't any explanation, of course, for why it was left to the very last moment. I accept all the limitations of what can accept that, but nonetheless, when actually just looking at whether or not it could have satisfied the test, then it was plain and obvious why the time period had run out. And of course,
why?
Well, because you've got a period of time of the 30 days in this particular case. The 30 days appeared to have been satisfied if on our construction, but not otherwise on any other construction.
But there, on any view, there were 25 days in which you could have got the arbitration claim form in.
Yeah.
So,
There's
no explanation.
There's
for
no
why
explanation.
That didn't happen.
I accept that. I accept that that's the case. I mean, nonetheless, my best point is there wasn't a whole world of facts that were there to be prosecuted. It was a very narrow, limited of facts, and it may be that within that there would have been a fault, but you can still satisfy the test by introducing some element of fault. I mean, in some of the cases that we've looked at, there's been 2 years delay and really big consequences, and with procedural problems caused as a result of that. And so it's all the knock-on effects. There were no knock-on effects whatsoever. It was a very short period of time. And the little snapshot of those emails tells us all that we needed to know. So apart.
So can I just see if I'm just summarising your argument?
Yeah.
The starting point is we have to work out what the words mean to a reasonable person, reasonable reader with all the background knowledge of the parties.
Yeah.
The word that is critical to the dispute is the word rendered. That word is not a term of art. It doesn't have a fixed meaning.
Yeah.
Whatever it means in clause 14.2, it doesn't necessarily mean the same thing in clause 14.3.
Yes.
The combination of time running from the date of the award plus the exclusion of any possibility of extending time produces such an unreasonable result that one really must ask, could the parties have meant that to be the position? That is the result of the judge's interpretation of the clause. One or other of those parts of his interpretation must be wrong. Either he's wrong about the meaning of the word render, or he's wrong about excluding the possibility of an extension of time. But to have both is so unreasonable as the court should not adopt that as the interpretation of the agreement. Is there much more to say, Mr. Davenport?
Not really, my lord. A little bit of colour on that. Just that the cases, of course, always cases, which would say the more unreasonable the result, the less likely it is. I mean, your lordship's extremely familiar with all that. And we quote extensively from your lordship's book, as your lordship might have seen, at paragraph 21. And of course, your lordship balances that by saying that's not a replacement for the importance of the language of the provision which is to be construed. So we're trying to say, well, we're either one or the other. We're either, please do just construe the language. We should win on that. And the second position is, but if you have to look at the commercial realities hinted at by all of it, then we should still succeed. So I think that's the only colour that I can add. Of course, I've got copious notes to deal with why all those add-ons weren't right, why the LCIA rules, which don't admit of an appeal in the first place, why you can't start looking around for justification. So that chapter is all about ICC rules, LCIA rules, the guidance note, and indeed the Act, that these are all secondary considerations. The primary considerations.
I think that's clear from the judge's judgment. He says this is what I've decided, and I'm to some extent reinforced by all this other stuff.
Well, my lord, that's your lordship's prerogative to say that. Our respectful submission is that the engine that drives is his realisation of the Act. That's why I showed you that first bit when he comes in and says, "Oh, hang on a minute, you chaps haven't thought about the Act enough." and then that's what we get put in front of us. So that's what I mean, I can't better myself by repeating it, but that's the slant that I'd like your lordships to deal with. I mean, I obviously had stuff that I would say a little bit further about extension of time in principles and in reality. I think I've given your lordship all that I can on that. I didn't give your lordship anything on threshold, of course. I mean, I gave as it were, a snapshot of what our position was, namely that you're in the CPR, and that's a significant point in our respectful submission, and isn't overtaken by the fact of the existence of it, an underlying Section 69 appeal. For the purposes of the application that we are appealing, we were facing a summary judgment application. And secondly is that in any event, a summary judgment application is, by common consent, a preliminary point and is interlocutory in nature. And it doesn't matter that it leads to the termination. It isn't something that should be treated as a once and for all appeal. And when you look at the authorities, there is no hard and fast answer about what is and what is not part of the decision-making chain. There isn't an authority that definitively concludes that that any part of the decision-making is enough. In the Manchester City case, there was lots of discussions between Lord Panic and I think the Master of the Rolls at the time.
Okay, can we just stick to the
Yep.
interpretation of clause 14 for
Yep.
the moment? We'll come on to jurisdictional questions if we need to.
Yeah.
So is that what you want to say about interpretation?
Yes, I'll just check with my lordship. No, thank you very much, Lord. No,
Right. Mr. Morgan, I think we'd like to hear you on the interpretation of clause 14, please.
Oh, yes. So, the court is intimately familiar with the various decisions of the Supreme Court, Court of Appeal on construction of contracts. It's an iterative process, putting words against the factual background. The one thing that one can be sure of in this case is that the factual background was the LCIA rules that were written into the contract. It's an LCIA English suit arbitration. And so one's looking to the Arbitration Act 1996 to understand the context within which the parties have access to the court.
Which version of the rules applied in this case?
The 1998 version of the LCIA rules, which is in the bundle.
Yeah, when you put both of them in the bundle.
I've got the, yes, but
The arbitration is started after 2020, but it's still the 1998 rules which govern.
the 2020 rules govern the arbitration, but the construction of the contract should be looked at against the rules as they existed at the date on which the contract was negotiated and agreed. That's sort of slightly odd dynamic. So what I'm trying to establish is what the parties knew at the date they entered into the contract.
So if you're looking, for example, at what they meant in clause 14 by rendered, you would look at, or you might look for help in the 1998 rules.
One might, but of course that's the date on which the decision is signed. It's the date on which the decision is, the award is dated in the LCIA.
Well, I would ask because the 1998 rules do use the word rendered in
I think
this
that's
context,
the IC.
but I don't think the 2020 rules do.
No, they don't. Indeed. So there's that. The second point is that, of course, challenges to the decision under Section 67 and 68 are mandatory provisions. The parties can't contract out of those. Parties can contract out of Section 69. So it was within the scope of possible deliberations in negotiating the contract that the parties could have contracted out of Section 69 entirely. Instead, they chose to put in a bespoke provision in clause 14.2 allowing for appeals. And that bespoke provision goes one way.
14.3.
14.3 goes one way and the other. So there's no requirement to seek permission of the court to make an appeal. There's no 28-day limit, but instead the parties agree a 30-day limit and exclude any right to rely on any other provision of the Arbitration Act. Could we go to the wording of the contract itself, please? In the core bundle, behind tab 1.
Yeah, page 11.
And if I was actually going to invite the court to start at 14.2b on page 10,
Yes.
because this is the first time the word rendered appears. The arbitration tribunal shall be appointed by mutual agreement of the parties and in default by the LCIA. The arbitration tribunal shall conduct its session and render its decision in English. Now, the reason I invite the court to focus on that is that it's the tribunal that renders the decision. It's no one else. It's not the LCIA that renders the decision. The LCIA has a secretarial role in transmission. So when one's looking at what the parties understood the language to mean and what the reasonable bystander in possession of all the facts would understand the word render to mean, one gets that from 14.2 as being the tribunal that renders the decision. It doesn't make any sense to say that the LCIA renders the decision. And it's the action of the tribunal rendering the decision, not the passive receipt by the parties.
At that stage, all it's talking about is it's only addressing the language on which it will conduct its proceedings and the language in which its decision will be given.
Your Lordship is entirely correct, but in my respectful submission, the draftsman and the reasonable reader turning over the page is going to be thinking about what is being described by the word render, just some subclauses earlier. And the word render, as I've sought to suggest, is an active verb indicating that somebody doing something. It's only the tribunal that renders, it's not the LCIA. And so I seek to say that when what we're looking for is the last active step taken by the tribunal in determining what the date is, and that is the date on which the award is dated. So there's an identity of analysis between what's said in the Arbitration Act and what's said in the LCIA rules at that date, and the understanding of the word render in the contract. So when one comes on to 14.3a and reads the last clause, provided that such appeal is brought within 30 days after the decision is rendered, that's looking for a certain date, a certain identifiable date. And the only date that is certain and identifiable is going to be the day on which the award is dated. Otherwise, one runs the possibility, if one were adopting my learned friend's analysis, of having multiple possible dates from which a 30-day period could run. It's the date of receipt. Is it proof of receipt? What is it? It's just an amorphous plea to, well, when do the parties get it? If they're in different time zones, what's the date of the award being rendered? And those are the sorts of problems that the legislature and the LCIA grappled with when they used the word, that they set the date as being the date on which the award is dated. That is a reasonable position to adopt for the draftsman of this contract, and it's the reasonable understanding of the parties as to when the award is rendered. And that is pretty much the long and the short of why we say rendered is the day on which the award is dated. It's rendered by the tribunal on that date.
Do we get any help from 14.3c,
14.3c,
which also uses the word rendered?
Indeed, yes. It's the date on which the award comes into effect. And that is going to be taken by court under the Arbitration Act as being the date of the award, because that's what's provided for under the Act in section 54 of the Act. And it allows for the entry in any court of competent jurisdiction of the award. Is it really likely that the parties intended that each court should ask itself, well, when was the award received by each of the parties? Could any court be confident that it had been received by each of the parties?
At that point, that's not a relevant question, is it?
No, I agree, but I was attempting to expand.
I'm not saying I disagree with you. I'm concerned about the overall thrust, but I'm not sure how much you can read into that. I mean, these peripheral points, because it works just as well if you're talking about the date upon which it was delivered by the CIA.
But that's not an identifiable date on the face of the document. One's
Going
going
to,
to
all 14.3c is concerned about is enforcement in another jurisdiction, and each jurisdiction may have its own rules about the award and its enforcement. I'm not sure where it.
It was a minor peripheral point in any event.
Yeah.
I entirely endorse your lordship's approach.
And you won't be able to enforce it unless you've got it in your hand.
You
And you can
unless-
show the court of competent jurisdiction, in which case you've already got it.
But it must, on Malone Friend's analysis, it couldn't have been rendered against his client if he hadn't received it. That is the essence and indeed the limit of the scope of the argument. The court will see the way in which this was all framed on page 25 of the court. In the application notice, and the reasons given are mercifully short and sets out pretty much exactly what I've just said. We say the award was rendered on the 11th of April, 30 days ran from then, and it was out of time.
Yeah.
Now, I entirely appreciate why this court wants to hear me on construction. There are some fantastically interesting points of law on the threshold test of jurisdiction.
Let's stick to construction for the moment, Mr. Moore.
My lord, it would be my submission that it's not open to this court to accept that.
No doubt.
Indeed. But unless I can assist you any further.
Well, do you want to say anything about Mr. Davenport's point that, in effect, he's drawn two short straws because the judge must be wrong about one or other of his interpretations? Either he must be entitled, at least in principle, to an extension of time. Whether or not he's actually applied for one is a different question. Or the judge must be wrong about the meaning he attached to the word render, but they can't both be right. Now, you've already emphasised the point that one of the elements of this bespoke regime is that a party who wants to appeal doesn't need the court's permission to do so. And so that bypasses quite a lot of the restrictions in the Act for appealing. But is there anything more you want to say on that part of Mr. Davenport's argument?
My lord, yes. In fact, it leads me into the second very interesting part of all of this, which is what is the effect of the parties agreeing to a contractual period for an appeal? And again, it's the basic premise of the Arbitration Act, party autonomy to agree the basis upon which disputes be resolved. Arbitration is designed to allow parties to achieve effective, speedy, final determinations. In this case, the parties have elected to agree a bespoke appeal clause, where they've gained something and lost something. They've lost the right under 14.3b to make an application or to appeal to the English courts under the Arbitration Act, except under 14.3a. Now, my learned friend says, well, that can't be right, because we can't have given up our right to achieve or to ask for an extension of time. However, when one looks at the way that Section 79 and Section 80 are framed, it would be my respectful submission that there is no power in the court to vary a contractually agreed time limit for the appeal. Because when one looks back at the wording of the rules, one goes to Order 3, when one looks at Order 3, one can vary time limits under the rules. When one looks at Order 62.9, one can vary the 28 days provided under the Act. But there is no power under the rules to vary a contractually agreed time limit. That is a hard stop, irrespective of 14.3b. Now there's quite a lot to unpack and develop, and one has to go through all of the rules and look at the precise wording. But it's not just the 14.3b provision that prevents an extension of time being sought. It's the agreement to the 30 days that does that.
Why doesn't 79.1 work?
Well, it's the exception. Hang on, must I just tell you that?
Well, the starting point for section 79(1) is that the court may by order extend any time limit agreed by the parties in relation to any matter related to the arbitral proceedings or specified in any provision of this part in default of such agreement. And the 28 days is specified in default of agreement.
Well, might we break this clause down very carefully? And it does. I'm going to invite you just to take a little bit of time to go through it. Let's leave out unless the parties otherwise agree. So we're going to take out 14.3b, which we say is the parties have agreed otherwise. So let's ignore that for a moment. The court may by order extend any time limit agreed by them in relation to any matter relating to the arbitral proceedings. This isn't in relation to the arbitral proceedings, it's in relation to the court. Or specified in any provision of this part having an effect in default of such agreement. Now it's not specified in this part because it's 30 days agreed by them.
I see.
So section 79(1) doesn't apply, even leaving aside the express contractual provision.
Yeah.
But forgive me, I thought we always read the words any matter relating to very widely. Why doesn't a time limit for appeal relate to the arbitral proceedings?
Because it's in relation to the court. That would be my submission.
Well, it's related to the arbitral proceedings because it's the time limit for appealing the result of the arbitral proceedings to the court.
Well, I hope I don't sound rude in putting it this way. If your lordship's interpretation of that subclause was correct, the next subclause, or specified in any provision of this part, would be unnecessary.
I'm not sure I understand that, I'm sorry.
Well, it may be that I'm just wrong, but my submission is that the Act itself covers extensions of time generally in relation. You can come to the court and say, I need more time within the arbitration to start my arbitration or whatever.
Yes.
That's in relation to the arbitral proceedings.
Yes.
Then there's a separate code that deals with coming before the court, and that's or specified in any provision of this part having effect in default of such agreement. Now, there are two aspects to that. In default of such agreement, and in any provision of this part. So it's looking at whether the court should, this court under section 79 should vary a time limit, section 28, the 28-day time limit under section 70 for making an application. But what it doesn't deal with is a position where the parties have expressly agreed on a time limit.
What does it apply to the 28 days? Because I think that's covered by 80 sub 5, isn't it?
Well, if it's covered by 80 sub 5, then one's looking to the rules of sorry, I have to go back to pre-1999. The civil procedure rules for the power to extend time.
Of 28 days.
Of the 28
Yes.
days. So maybe just have a quick canter through the two possible options.
But that's not what we're dealing with here on any basis, is it? We're not dealing with extending 28 days.
No, we're dealing with extending 30 days.
Yes.
Section 80 sub 5 is where any provision of this part requires something to be done.
Yes.
And it's not a provision of this part that requires it to be done within 30 days. Sorry, within 28 days. Because it's a contractual provision.
Yes.
So we don't get into 85 at all anyway.
Yes.
And even if one did get into 85, then there are only two possible options. CPR 3.12a, which allows the court to extend or shorten the time for compliance with any rule, practice, direction or court order. We're in a contract time limit. Or 62.9, which is to do with the 28 days allowed under the Act.
No, but you have 79.1.
Well, but what I'd hope
That's
to do...
that's the only power, as I understand it, which would enable the court to extend the 30-day time limit. Your point is it doesn't.
It doesn't, yes.
But if it does, then you would say the parties have otherwise agreed because they have excluded that provision.
Yes.
Yes, I understand.
And so one...
And that's what the judge decided.
Yes.
And under section 79, of course 6, the leave of the court is required for any appeal from a decision or order of the court under this section. So we're still back into the same
Yeah, well,
jurisdiction.
we're leaving that
Yeah.
for the moment.
I know, but I couldn't resist trying to at least finish off that.
Right.
So we say that it's a bespoke clause, the parties have gained something, lost something, and it's no answer just to say, oh, well, it looks frightfully harsh at this end of the telescope.
Yeah.
Both sides signed up to exactly the same provision.
Mhm.
It's even-handed as between them. Unless I can see.
Right. What's your position about whether was an application made for an extension of time?
My lord, no, and you can see that my learned friend was quite candid with the learned judge. It's at page 78 behind divided 5 in the core bundle. Page 78 between A and B.
I think the position was they were thinking about it but hadn't done it yet.
Indeed. So there's been no application, no grounds, no evidence from them, no evidence from us.
Well, the suggestion seems to be that somebody thought, unidentified, that the 30 days ran from the 16th of April. But that hasn't actually been said, and certainly no evidence to support it. I've seen that Mr Ross was asking how long they had, but there's nothing further to indicate that somebody then, in this hypothesis, misunderstood the position.
No, and indeed, what's said by what's said on behalf of Mr Eronat is that Mr Ross was alive to the fact that there was an issue. And that's supplementary bundle, page 153, paragraph 6. And you've seen the exchange by email from which that is a quote. So it's positively averred that they were alive to the time limit, and indeed in their arbitration claim form they set out that they say, well, if we're wrong on the construction, then we will do something about it, but they never do. So they had the time to draft a claim form that says, well, we're aware of this problem, but they don't explain why they drafted it that way, how they had the time to draft it, why they didn't just put in a claim form and make an application. But there we are. That's where we are. That's getting rather beyond the construction point.
Right. Mr Davenport,
My
you want
lord.
to reply on construction?
Well, just on construction, yeah, I think 14.3c was an interesting moment in time when your lordship asked about it, because I don't think that 14.3c really featured whatsoever below, or if it did, not very much. And I don't believe it was any sort of part of my learned friend's argument. So whether he was jumping on a particular bandwagon, then I just simply don't know. But it kind of underlines the point. The only point I wish to make is that the word well, 2 points. One, I've made countless times, rendered isn't a term of art. And that's made good by the fact that it's used the 3 times that we can see. And in each time it means something completely different. And it's not a word that lends itself to only having one type of meaning. I'm not suggesting it's crystal clear. It is relatively nebulous term with potential other meanings available to it. I readily accept that that's the case. And you can see that 14.2b, sorry, B, and 14.3a and 14.3c, they're all different contexts. So there's not a universal reading that can be used to just transliterate. And as you can also see, as your lordship pointed out, that 14.3c can only effectively work unless it has been received, processed, and hence understood. So it has a completely different meaning. Even I'm not suggesting 14.3c can be read backwards into 14.3a. So that's really the most important point that I want to get across to your lordship, is that there isn't any universal use of that particular word. 2b doesn't therefore relate to 14.3a, and you look at it, it's just talking about the language in which something should be rendered, i.e. it should be in the hearing should be in English, and the award should be in English. It doesn't talk about time obligations on behalf of the parties. It doesn't interrelate to 14.3, and it's not cross-referred to 14.3 in any way, shape, or form. So it's a freestanding example of why, in this instance, you can't read, as the learned judge said you must read, the word in 14.2b across. He didn't say that, as far as I'm aware, in respect of 14.3c. So I'm afraid it is a term that just needs to be looked at, obviously with the understanding of the whole of the contract, as we talked about earlier. But nonetheless, it comes down to 14.3b, and with the points that I've made earlier, we just ask your lordships to accept that it couldn't, to these parties, have meant anything other than that you've been notified of it, that you have received it. Anything else is straining it. And my last position was, unless this was a determination of the point of law, and it was actually more a summary judgment application, it certainly was a sensible argument. And whoever was going to determine it whenever, it was something that should have survived a very short 1-hour application in the afternoon. Those are my submissions.
Right, we will just rise for a few minutes. Don't leave the courtroom, and we'll take stock and see where we go from here. Thank you.
Court rise if able to.
The female Tour de France is going past my parents' house in front.
Yeah.
They go up a really steep hill. As kids took us to get to the top in a matter of seconds.
Yes. So your parents just sit there with Joe's height watching them go
They
by.
sit there
as
waving,
they're sweating away.
waving the Union Jack.
They
And,
go amazingly
they
quick.
were, yeah. There's the
Yeah.
hours of cars and people firing t-shirts. Well, they did in 1994, but that's, which is the last time. But they did anymore.
Court rise if able to.
Well, we've heard argument now on the interpretation of clause 14.3. The question being whether the judge was right or wrong in his interpretation of that clause. And we have come to the conclusion that on the assumption that we do have jurisdiction to grant or refuse permission to appeal will be refused. We will give reasons in writing at a later date.
In those circumstances, we would ask for an order for our costs to be assessed if not agreed.
Mr. Davenport, you can't
Yeah,
really
I can't
resist that,
resist
can
that,
you?
I can't
No,
resist that.
all right. Well, perhaps you'll draft an order.
Well, yes.
Thank you very much.
Court rise if able to.